Good morning, Ms. Hawkins. Ma'am, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am.
Yes, Judge. On March 6, 2025, at approximately 10:29 p.m., the officer observed a vehicle driving with expired registration as of March 2021. A traffic stop was initiated. However, the vehicle continued to travel down the feeder road until it turned and pulled onto the wrong side of a two-way road and parked facing northbound in the southbound side of the roadway. The officer made contact with the defendant, the driver and sole occupant of the vehicle, and observed the defendant to have bloodshot eyes, droopy eyelids, and a strong odor of an alcoholic beverage. The defendant admitted to drinking 1.5 alcoholic beverages, and the defendant stated she was buzzed but not drunk. An inventory search of the vehicle was conducted, and the officer found a large plastic cup that was 1/4 full of alcoholic beverage that smelled of tequila in the center console cup holder. Standard field sobriety were conducted, HGN 6 out of 6, walk and turn 5 out of 8, one leg stand 3 out of 4. The defendant was read the DIC and refused to provide a specimen. A blood search warrant was signed and executed.
Are you telling me that she has alcohol in the car while she's driving?
She had a cup of alcohol.
Ms. Hawkins, I'm going to find that there's sufficient probable cause to go forward with your case. I am now placing several conditions on your bond. If I find that you violate these conditions, I will revoke your bond, put you in jail. No more PR bonds, ma'am. You're not allowed to drive. I'm taking away your privilege to drive. You will be signing an affidavit with me today promising me you're not going to drive. I don't care what's going on in your life. If I find that you do, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine. This is an affidavit that you're going to promise to me that you're not going to drive. Do you understand?
Yes, sir.
I'm also ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. If I find that you're consuming alcohol or illegal drugs, likewise, I will revoke your bond, put you in jail, ma'am.
Judge, is that a standard for driving?
She has alcohol in the car while she's driving. And so I would presume that it's elementary that you're not to have alcohol in the car while you're driving. It scares me, and I just don't want her driving for...
On March 7, 2020, 23-year-old Keelan Hawkins was arrested in Harris County and charged with driving while intoxicated, then released the same day on a general order bond under Harris County Local Rule 9, which mandates that, with limited carve-out exceptions, most misdemeanor arrestees receive an unsecured personal bond and are released automatically without a judge's prior approval or an in-person bond hearing. This system, unique to Harris County, stems from the November 21st, 2019 consent decree in O'Donnell v. Harris County, a class action lawsuit challenging the county's former misdemeanor bail practices as unconstitutional and resulting in sweeping bail reforms, including the general order bond. Following her release, Hawkins' arraignment was set for March 13, 2025, before Judge David Fleischer, whose role was to assess probable cause for the DWI charge and revisit the issue of bail. Although her attorney of record was Greg Holton, the arraignment was handled by his colleague, Aaron White.
Understood.
We can approach at a later date, but I'm
concerned because for her employment, she can't get to and from work, and we can't get an occupational license or something like this. It's a condition of the court. I don't think we have any opposition to putting an interlock in the vehicle so that she's not able to drink and then drive. But it just seems like no driving at all seems a bit harsh for a first offense. We don't even know what the blood is at this point.
Get it? But she has alcohol allegedly in the car while she's driving. One would presume that that's a humongous no-no, you know? And I want her to appreciate the privilege it is to drive. It's not a right. It's not a right. It's an absolute privilege.
Judge, if I may, what would be the conditions under which she's able to come back and get permission from the court? At what time frame?
I need to know that she understands and appreciates the privilege, you know, be proactive. It's not forever, Aaron, you know, but I want her to understand that it's a privilege, it's not a right, and it's something that people should take very seriously.
I mean, is there something we can do? Because, you know, if it's something that you'd like her to do while on bond to make sure that she's, you know, addressing the issue, I mean.
Be creative, be proactive. I want to know that she appreciates it, and I'm all ears, you know, but it's something that I've seen her do more and more. where there's alcohol in the car. And I would presume that you would know, especially at this age, that,
Well, to be fair, Judge, the allegation is that she violated the law. The presumption is that you would know not to violate the law, period. I personally don't think that the fact that there is possible alcohol in the car, I don't think it's been tested, but it just seems like no driving at all seems like a harsh penalty for someone who's never been arrested before, no criminal history. These are allegations. There's a blood draw pending. According to the dim summary, she had 1.5 drinks. It's certainly possible her alcohol level comes back below the legal.
After finding probable cause for the DWI charge, Judge Fleischer imposed conditions on Ms. Hawkins' bond that went beyond what the prosecution requested, ordering her not to consume alcohol and not to drive at all, even though the state had only sought installation of an ignition interlock device, IID. Under Article 17.44 of the Texas Code of Criminal Procedure, an IID is mandatory only for repeat DWI offenders or aggravated cases, such as DWI with a child passenger. And because Ms. Hawkins was a first-time offender, the statute did not require one in her case. However, Article 17.40 grants judges broad discretion to impose any reasonable bond conditions related to community safety. And while such conditions cannot be used as punishment before conviction, appellate courts, following the abuse of discretion standard explained by the 14th Court of Appeals in the 2022 case Ex Parte Bucks, will uphold them so long as they fall within the zone of reasonable disagreement. Given the allegations that Ms. Hawkins was driving while intoxicated and had an open container in her vehicle, it is highly likely a reviewing court would find Judge Fleischer's restrictions on drinking and driving reasonably related to public safety, and therefore not an abuse of discretion.
And if that takes 90 days to get those lab results and come back and get this taken care of, she's not driving for 90 days.
I'm not saying that long, Aaron. I just want some kind of proactivity that I know that she appreciates come back and,
And just
Hey,
for Craig's purposes, so I can convey this debate. What's proactivity to the court?
just be creative.
Okay.
Be creative. And, several weeks, come back and we can talk. But it's a privilege. It's not a right. And it's something that we take very seriously. Every single day, someone dies from a DWI in our county. Every single day. And we need to ensure that it's taken seriously. I'm not asking for much. And once we know that there's appreciation, then let's talk again.
Mr. White requested driving privileges so Ms. Hawkins could commute to and from work, but Judge Fleer maintained a zero driving condition on her bond for the time being. It is important to note that bond restrictions are separate from the status of a driver's license under Texas's administrative license revocation process. Because her blood test results were not yet available, her license was likely not administratively suspended at the hearing. However, under Article 17.40 of the Texas Code of Criminal Procedure, judges have broad discretion to impose reasonable bond conditions for community safety, which explains why Judge Fleer could prohibit all driving or, alternatively, allow limited driving to work while barring other trips. If her blood results later showed a BAC of 0.08 or higher, the Department of Public Safety would suspend her license under Section 524.012 of the Texas Transportation Code, which mandates suspension for driving above the legal limit. Even if Judge Fleer later lifted the bond restriction or granted limited driving privileges, Ms. Hawkins could not lawfully drive unless she obtained an occupational driver's license under Section 521.242, which permits driving for work, school, or household duties despite an administrative suspension.
How's it going?
Oh, good. Thank you.
How has it been? Not tough, isn't it?
Yeah.
Sucks. Living in a city as big as Houston without the ability to drive blows. And the only thing that I'm trying to get to you is to understand that it's a privilege. It's not a right. Every single day on our streets, someone is dying from some kind of alcohol-related collision. That's what we're trying to impart to you here, to take it seriously. It's not a joke, and the last thing I want is for something like that to happen here. You understand?
Yes.
All right. I'll take off the restriction. Okay.
Judge,
What does she have now? I want to make sure that she has an interlock for now, just for a limited time.
Judge, if I could speak to that briefly,
Sure.
just to reassure the court that she fully understands the court position. I had her research and write an essay on alcohol-related accidents and fatalities. We can turn that in and take a decision-making course. Her case is a stop for expired registration, no accident. You got the blood this morning, it's a 1-3. She has no criminal history. So I would ask the court that to use this, the research she's done in the 28 days without driving at all, to understand that she gets it. And if we can not have the interlock, as would have been if she didn't have an open container, that we proceed further and let us do the work of getting the discovery move forward.
Okay.
I can turn those in.
I want you to know I will act to your lawyer, but if I find that you're using alcohol, I'm going to blow a gasket. I'm really just going to lose it. Just don't. That's all I'm asking you to do. Do you understand?
Yes.
Okay. I'll take a look at this. I'm going to acquiesce to you.
Thank you, Judge.
Just don't. Life is too short to spend the next month in a 6x9.
Mr. Holton informed Judge Fleer that Ms. Hawkins' blood test returned a BAC of 0.13, exceeding the legal limit of 0.08. Despite this, Judge Fleer agreed to remove the no driving condition from her bond and, at Mr. Holton's request, declined to require an ignition interlock device. Nevertheless, because her BAC exceeded the legal limit, her license was likely subject to administrative suspension, meaning she could not lawfully drive without obtaining an occupational driver's license from the court or successfully contesting the suspension. Since the administrative license revocation process is separate from criminal proceedings, it was not addressed during this hearing, and as of this episode, her DWI charge remains pending. In this case, we saw Judge Fleer exercise the broad discretion granted to him under Texas law to impose and later modify bond conditions, initially barring Ms. Hawkins from driving and consuming alcohol despite the state requesting only an ignition interlock device, and later removing the driving restriction while still declining the IID. Bond conditions serve as tools for judges to balance community safety with allowing defendants to remain out of custody while their case is pending. While some may view the initial restrictions as strict given the limited record at arraignment, others may see them as cautious temporary measures intended to reduce risk until new information arrived, which is exactly what occurred here. Ultimately, judges have broad authority under Texas law to set reasonable safety-related bond terms, making the initial driving ban lawful even if it felt harsh to Ms. Hawkins.